Okay, I've already posted a video about spotting a substantive due process issue. So I want to talk now much more substantively about how to tackle, right, a substantive due process problem. And now that it's review week, again, I'm not going to rehash every single thing that we talked about over the course of the past 13 weeks, but I do want to provide a checklist before we go over our review questions, right, of the material you need to know, right, in order to handle a substantive due process question, either on my exam or on the bar exam or in practice. So first, once you've determined that substantive due process is the body of law that you are applying, you have to be comfortable with the text, right, with the Ninth Amendment, which says there are unenumerated rights, which the 10th Amendment, which seems to suggest 3 spheres of jurisdiction, right, including federal, state, and people, right, and substantive due process, of course, being concerned with the latter, right, with the jurisdiction of people and individuals. And then you have to determine what level of government you're going after. Is it the federal government, or is it a state or a subdivision of a state? That guides you to either use the 5th Amendment, right, for the feds, the due process clause of the 5th for the feds, or the due process clause of the 14th Amendment for states and subdivisions of states. Next, you need to know the list of rights, or again, this is a little bit ironic, right? We developed a list of rights, but they're a list of unlisted rights, right? So they're not listed in the Constitution, but we know, right, those things, marriage, marital privacy, procreation, all that stuff, right, again, which I covered in the issue spotting video. You need to know your list, right, so that you can spot when the court has already said that that is a fundamental right. Now, if the right at issue in your fact pattern is not already a fundamental right, then you need to move to the next question, right, which is, should it be a fundamental right? And I haven't dumped the whole outline on this slide, but you know how to do that, right? So you need to know that. The factors that you would apply to decide whether a right is fundamental would be, is it deeply rooted in our nation's history and traditions? Here, you need to understand originalism, right, and how originalists tackle that versus living constitutionalists, right? But that's the first factor. The next factor is whether it's implicit in the concept of ordered liberty, right? So those are the factors you consider to decide whether a right is should be fundamental. So you need to understand those by now. You should have no problem with what each one of those means and how you apply each one. You need to be familiar, fourth, with the drift, right, that the courts have taken away from economic rights. This is related to what's coming next, right, and towards rights that involve privacy. You need to understand that there is no free-floating, overarching, right, general right to privacy in the Constitution, but there are certain discrete things, right, that the court has said that are related to the idea of privacy, and this comes from Griswold, right, the Griswold case, that that the court recognizes as fundamental rights. So not all privacy is a fundamental right, but there are certain rights that are fundamental privacy interests. Let that marinate for a while if you need to. So you need to be familiar with that, and the vocabulary, right? What is a penumbral right? Lawyers, most people don't know what politicians or judges mean when they say penumbral rights, but lawyers do. So you need to know that vocabulary. Fifth, you need to be comfortable and have no problems, no troubles with dealing with economic rights. Anytime you see an economic right on an exam or again in practice, you don't go for it. Economic rights are now low-level rights, right? Lochner has been overruled, so you would apply rational basis review, right? Anytime you see a low-level right, and by rational basis review we mean Lee optical, extremely deferential to the government, right? The government can mess around with people's economic rights. Now, speaking of these levels of review, that's obviously number 6. And although it's number 6 on your checklist, it's probably the most important thing for passing a bar exam is to know your standards of review, right? And in substantive due process, unlike in equal protection, which we'll talk about later, excuse me, there are only 2 levels of review, right? And those are strict scrutiny and rational basis review. It should go without saying that if you don't know how to apply strict scrutiny at this point, common law is going to be a disaster. Common law 2, right? Under strict scrutiny, You must identify the burden. And I'm talking here about how you would do a full analysis, right? If the call to question is narrow, we've talked about this, right? If the call to question is narrow, then just answer the call to question. But this is everything you need to know, right? So you need to know that under strict scrutiny, the burden belongs to the government. The burden of persuasion, that is. You need to know that under strict scrutiny, you have to identify a compelling interest. This brings me to another point. You need to know how to find the interest in a fact pattern, right? You have to identify what is the government's goal, what is it trying to achieve, right? And that would have to be an important interest, save the children and all that. Obviously, you also need to understand the narrowly tailored means prong, right, of strict scrutiny, and you need to be comfortable with how that works and with the way the courts use that, right? And certainly you should be aware that that is the part of strict scrutiny that is usually fatal. Then, of course, you need to be familiar with rational basis review. The burden of persuasion, right, switches over to the challenger. The challenger has to show either that the means are not legitimate, that the ends are not legitimate, or that the means are not rationally related to achieving some legitimate purpose. So once again, under either of these standards of review, you have got to be able to identify from the fact pattern what is the government trying to achieve, and then when you get to the means part, how is the government trying to achieve it. So mastery of the levels of review is obviously important. I'm going to do another short video about abortion to cover those rules, but obviously abortion falls under substantive due process. That really is important for you to understand that this is a substantive due process issue, right? The abortion cases are due process cases. They are not equal protection cases or enumerated rights cases or any other kind of case. They are substantive due process cases, but they have their own tests, and courts have a different approach to handling those cases. But at any rate, at least be aware, right, which clauses apply, right, the 5th and the 14th amendments. You of course need to be aware of the what I put here as the morals question, right? It's an open question where the court is going with that, but again, under Justice Kennedy's approach in Lawrence versus Texas and other cases, morals standing alone is not a legitimate interest, right, for state action. There should be some other interest in play, like, probably health and safety would be the safest bets. Finally, and again, this is just a checklist, right? This is like an attack. You should be looking at each one of these 9 things and saying, do I understand that thoroughly? And if I don't understand that thoroughly, get online, go grab a treatise, right? Do something to bone up on it. But the final thing that occurred to me to put on the checklist is, right, this is related to substantive due process, that the reason substantive due process exists is that the court killed the Privileges and Immunities Clause of the 14th Amendment in the Slaughterhouse case. So you need to be prepared for that. Now, P&I, we may see some actual P&I cases coming up here in the not too distant future because of the way states are restricting interstate travel. So that's one of the only things that the Privileges and Immunities Clause applies to, the only thing you have to be concerned about. Other than that, anytime you see a claim under the Privileges and Immunities Clause of the 14th Amendment, as opposed to the P&I Clause of Article 4, right? If it's under the P&I Clause of the 14th, your correct answer is the case would be dismissed for failure to state a claim because P&I doesn't protect anything anymore. So that is a quick checklist. Again, we're going to do a lot more some more discussion of this when we do our live session review. But I wanted to get this posted so you can at least get your substantive due process outline internalized. And we'll be talking about abortion next, and then a little later on, in the next couple days, also talk about equal protection and the First Amendment. Be well and stay tuned.